men and women who couldn't defend themselves, and they charged them with being witches. Based upon statements of other people and evidence that could clearly be explained if given an opportunity. They subjected these men and women to tests. They would bind them at their hands and their feet, and they would throw them in the water. And if they sunk, they weren't a witch. But if they floated, they were immediately taken up and burned at the stake. The American legal system has come a long way since the witch trials of Salem. We have DNA, we have fingerprints, we have forensic evidence that can tie someone to a murder. But the state would like us to go back there and convict Mr. Drath on statements made by people and evidence that can easily be explained. Mr. Drath is here today fighting for his life because the state has accused him of murdering Mr. Walker. And to meet their burden of reasonable doubt, they give you no evidence. You'll likely hear, when the state gets back up here, direct and circumstantial. And let me unmurky these waters for you really quick. If you look outside and you see it snowing, there's direct evidence that it snowed. But if you get up the next day and it's January and you notice snow on the ground, you know beyond a reasonable doubt that it snowed that night. The state hasn't given us a murder weapon. They haven't given us a fingerprint. They haven't given us blood, shoe print, or any direct forensic evidence. Their case is purely circumstantial. But it does not meet the burden of a reasonable doubt. You heard from Dusty Stockard, an investigator who investigated the scene of Mr. Walker's death. You heard that he found Twitter messages between Mr. Drath's daughter and the decedent, Mr. Walker. You also heard that he then called Mr. Drath. And no matter how the state tries to characterize it, Mr. Drath's first response was, "I didn't do that. I didn't kill Mr. Walker." The state wants you to jump all the way across the pond to conviction based upon a Google map and 2 shell casings. The state also told you today that Mr. Drath wasn't the only one who lived in his house. He wasn't the only one with access to his computer. He wasn't the only one who wanted to know where Mr. Walker lived. You heard from Dusty Stockard that the only other person who wanted to know where Mr. Walker lived wasn't even investigated, wasn't interviewed, wasn't talked to. Sally Drath has had nothing to say. The bullet casings, based upon unscientific evidence of weight and visual comparison, those 2 bullet casings would have matched the millions of other bullets manufactured at the same time that those 2 were. Counsel brings up the point or asked you the question, why a bullet was in his pocket. But he never asked you, when was the last time you wore that coat? He never told you that he wore that coat in the interim of 5 years. We then heard from...
Objection to facts not in evidence. Heard testimony that the bullet was found in the defendant's pants. There's no claim that it was found in his coat.
Your Honor, this is a convenient mischaracterization of the evidence. For the entire course of this 3-hour trial, the bullet has been in his coat. Now it is miraculously in his pants when I've proven that there's no way to tie that bullet to this particular crime in a temporal time frame.
It's not particularly convenient, Your Honor, that Dusty Stockard testified on the stand that the bullet was found in the defendant's pocket on this person.
then heard from Mr. John Draft, who told you, as any other reasonable father would, after he found out that his young daughter was dating an older man and was sexually and intimately involved with this man, he became enraged. Ladies and gentlemen of the jury, we don't convict people for being enraged. We don't convict people for being angry. We don't convict people for having malice intent. We convict people for their actions. And what the state has failed to prove today is that Mr. Draft's actions led to Mr. Walker's death. It can't be disputed that Mr. Walker was shot and that Mr. Walker is now deceased. But the state has offered no evidence or testimony to suggest that Mr. Draft committed the act. There's a second question that you have to answer here today. Whether if Mr. Draft committed those acts, he can be held criminally responsible. And to that, you've heard two witnesses. You first heard from Christy Ciccone. First time in the box. First time on the stand. Offering an opinion based upon a half-an-hour personal interview and tests conducted by someone else. She told you just how important psychiatric testing is in reaching an opinion. And she also told you that she didn't do anything. You then heard from Dr. Chris Johnson, who got on the stand, explained to us the psychological testing she did and what she found because of it. She showed us the psychotic V. And she told us that the presence of this psychotic V suggests hostility, impulsiveness, and subjects the subject to delusions. Now, the state will have its opportunity to come in before you again. But do not let them do the law to you. They had a burden, and they failed to meet it. Just as they failed to meet those burdens in Salem. Just as they failed to determine that those subjected to those trials were witches, they have failed to prove to you today that Mr. John Draft is a murderer.